Good morning, everyone, and welcome to our ASATA webinar. With us today, we have our legal eagle, Elizabeth de Stadler from Novation Consulting, and Fatima van Toorn from FVT Consulting, our labor expert, giving you some practical labor advice on leave, what to apply for and when, the UIF, reducing salaries, retrenchments, and also just a little bit of an update on the President's announcement yesterday and what that means for you. So as you can appreciate, we are in unprecedented times, and we are very grateful to Elizabeth and Fatima for coming out so soon after the President's announcements to help us with that practical advice. We thank you for coming and listening in to us, and also we'd be very grateful for all your questions. So if you do have a question, it's very easy to ask. All you need to do is go to the Q&A folder at the bottom of your screen, type your question in throughout the session, and at the end, we will pose those questions through to Elizabeth and Fatima. So again, click on the Q&A folder at the bottom of your screen, type your question, and that will come through to me. Also, don't forget, we do have a coronavirus website for ASATA. We are updating that website continuously. Please go and check it out if you haven't. It's coronavirus.asata.co.za, coronavirus.asata.co.za. And of course, if you have any questions about the microsite or anything that you're coming across, you are also welcome to email us at asata@bigambitions.co.za. So with that, I'll hand over to Elizabeth now to take you through the rest of the presentation. Elizabeth, floor is yours.
Thanks, Natalia, and thank you to Fatima for joining us. As you pointed out, things are happening at a rather alarming pace. And we thought before we delve into the employment implications of what the country is going through, that we would just quickly recap what the President said last night, and then very importantly talk about what we know right now and what we don't know, and how ASATA is going to go about finding out for you what the information is and putting it all together. I want to encourage everybody to ask as many questions as possible. We will be creating a monster of a FAQ, which we will keep updated throughout the next 72 hours as the different ministers that are responsible for rolling out this plan gives us more information about how things are going to work. We are also planning to provide you with a bit of an HR toolkit. There are some letters and some forms that you will require to navigate all of these issues and all of the resources that the government is making available for us. And so just ask your questions so that we can make sure that we address it properly. I'm going to go through what the President said last night now. Then Fatima and I are going to conduct a little interview just to talk through the biggest labor implications and strategies that you can employ in the next 21 days. And then after which, Nat and I will pick a couple of questions to answer if we have time, on the air. The other questions we will answer in the FAQ as the week progresses. Right. So, firstly, what did the President announce last night? I think all of us are still coming to terms with this speech. Luckily, we have a president that is more eloquent than many of the other world leaders. And so basically we are in a lockdown. What this will mean is still unfolding, but the principle is that all South Africans must stay at home until 12 o'clock on the 16th of April. There are obviously essential services that still need to take place, and we are waiting for the President to publish the list of essential services. But if you are not on that list, and it's highly unlikely that any of the travel businesses will be on that list of essential services, we must all stay home. If you can work remotely, that is obviously allowed. They have also said that they will now turn back international travelers from high-risk countries. They've not yet updated the list of what they consider high-risk countries. It's fairly likely that in the coming weeks that's basically going to be everywhere. And then international travelers who arrived after 9 March are going to be confined to their hotels for a 14-day quarantine. So those are the sort of implications that we can share now about the lockdown. A lot will still be announced from about 10 o'clock today by the various ministers. And as we've seen in other parts of the world, there are various things, even though we are in lockdown, that we may still do. And that will become clearer as the day goes on. Then they also announced the first phase of the country's economic response. Firstly, they announced the Solidarity Fund, and the aim of that fund is to save lives and support the economy. That fund already has received a generous 2 billion rand donation from the Oppenheimers and the Ruperts. And that money will go towards, firstly, bolstering our health services, but secondly, also to support businesses in the economy. And the board of that particular fund will make their plans known to us in the coming weeks. Then there's also a special dispensation for companies that are in distress. We're still not sure exactly what form that will take, but here are some of the things that the president already announced. So firstly, they have set up a temporary employee relief scheme to facilitate wage payment and avoid retrenchments, and we'll talk a little bit more about that later in the webinar. The COIDA, so compensation for occupational industries, injuries, not industries, and diseases, now also covers COVID-19. So if someone contracted the virus while they were at work, there's compensation that you can get access to COIDA. The banks will meet regarding debt relief. That has taken a while because they first needed to get a competition law exemption. Then they are going to use the reserves within the UIF system to extend support to employees who lose income. That we already knew about, but the details of that is also still unfolding. Then there will be an employee tax incentive for employees that earn less than 6,500 Rand, and said that will be up to 500 Rand per employee. It looks like this is something that employees will have to apply for, not the business itself or the employer. SARS has undertaken to accelerate payment of reimbursements, and they're also going to reimburse more regularly. Then businesses with a turnover of less than 50 million will be able to defer a part of their PAYE obligations as well as provisional tax. They are not going to give us a tax break. This is just a reprieve from paying, and they have said that they won't penalize businesses. So this could be a source of some additional much needed cash for businesses. They are also going to access more of the UIF and make a reduction of our UIF contributions as well as our skills development fund contributions. So that should also free up some cash. Then the Department of Small Business Development has made 500 million available for SMMEs in distress. And there is also a 3 billion Rand fund in industrial funding for vulnerable critical firms. So that will be available also for the bigger businesses that are undoubtedly also going to take some strain. And then last but definitely not least, the Department of Tourism, has made 200 million available to assist SMEs in the tourism and hospitality sector who are under particular stress due to the new travel restrictions. So when we publish our FAQ, we will include instructions on how to access these various schemes. If I go back a slide for a moment, certainly the Department of Small Business Development, the registration for access to those funds have already gone live as of today, and we will share with you where you can apply for these measures. Right. So now let's talk about what we don't know. We don't know for the most part how all of this will work. We know that the various ministries will address these issues from about 10 o'clock this morning, although now I hear it's 11. Then we don't exactly know who qualifies, what you must do to qualify, and when it will kick in. Government is busy drafting the necessary regulations to put this into law. Certainly, if the speed with which they moved last week, if we take that as an indication, we should know a great deal more within the next 24 to 48 hours, and we'll keep you updated. Just give us your questions, and if we don't know, we will say we don't know, and we will definitely update you as we learn more. Right, so now let's talk about the labor implications of the lockdown. And we are going to talk basically about 4 things, but we will see where the conversation leads us, and then we will look at the questions that you have asked. Firstly, I want to ask some questions about retrenchment, because that is something that I think is on everybody's mind. I want to talk about other strategies like temporary layoffs, that we can take in the next 21 days in order to minimize the impact of the lockdown and of the virus. We're going to talk a little bit about what we know about the UIF, COIDA, and then TERS. And then we're going to ask some questions around what the story is with leave, because of course some of your employees will continue to work remotely. They may still be healthy. Some of them will get sick, and it's important to know which type of leave to allocate in which circumstances. Right. So without further delay, I want to ask Fatima, firstly, thoughts on retrenchment right now. Should this be something that businesses are thinking about? How should they be thinking about it?
Right. Hi, everybody. It's Fatima here. As I've just been introduced, I basically would not recommend that companies go straight into Section 189 processes, which is basically Section 189 is the section of the Labour Relations Act, which governs retrenchment or restructuring processes. And there's also Section 189A, which is for large-scale retrenchments, but we'll go into that detail a bit later. But the bottom line is I don't recommend that companies, as I said, go headlong into retrenchments. The president, in fact, said that last night. This is not the time to just start willy-nilly retrenching. I do understand that a lot of employers don't see the future being bright even after the 16th of April, and that they see long-term negative adverse ramifications because of COVID-19 and just what the economy is going to do after this period. So the idea is to look at strategies to try and circumvent retrenchments. And my advice to clients and generally and businesses like yourself is to say, just look ahead and say, which of these people that we currently can't afford in a business we will need in the next couple of months, because COVID will be over at some point. And I understand that the delay in the travel industry and hospitality industry is going to be a long one. I get that. But if you know that you're going to need these people in your business, in the foreseeable future, it makes no sense to retrench them right now, because some of you may or may not know this. Whether you embark on a short-term or a small retrenchment process or a large-scale one, either way, after the person is left for 12 months, in the event that you need to employ somebody again in the period of 12 months after the retrenchment, as per our legislation, you are obliged to reach out to the people that you've made redundant when positions arise. So basically, if it's a new position and you didn't have those kind of people in your business and they can't reasonably accommodated or trained into the new position, then of course you would have the right to go and employ new employees. But if it's positions that you had before in the last 12 months and there are people out there that you've made redundant, you are obliged to reach out to them and reasonably accommodate them. In other words, if they need to be retrained or somehow reacclimatized, you have a legal obligation to reach out to them. So what I'm getting to is it makes no financial sense to make people redundant in these times, pay out retrenchment packages, because as you probably all know that when you retrench people, you still have to pay out their notice periods, whether they serve them or not. You still have to pay out their leave accrued as at the date of retrenchment. And you need to pay severance pay, which is based on 1 week for every completed and continuous years worked, unless your business has a different retrenchment policy. But in terms of Section 41 of the Basic Conditions of Employment Act, the minimum is 1 week for every completed and continuous years worked. So A, it's going to cost you money to retrench people now. B, in the event that you need to re-employ people that you're going to retrench now, you're going to end up having to re-employ them, but now you would have paid out, in some cases, many years severance pay and all the other payments. So
if we pause for a moment here, because I think that is a very, very, very important point. I think that for a lot of people, and I myself fall in this category, that doesn't know a lot about retrenchment, might think, and you hear talk of it, that retrenchment is a way to improve your cash flow situation. But what you are saying, and correct me if I am wrong, is that retrenchment, in fact, is not a particularly good strategy to protect or conserve your immediate cash flow, because it comes at a fairly high cost.
Absolutely. And Elizabeth, some employers will not have the cash flow now, especially if it's a large scale retrenchment. And just to quickly touch on that, if you employ more than 50 staff, and there's a good chance that you need to retrench more than 10 people, you automatically fall into a 189A, which means you have to consult for 60 days before you could make people redundant. So that means you've got to carry the cost for 60 days unless those employees waive their right to 60 days. And in today's times, employees are not easily going to waive their right to 60 days, knowing that there are jobs out there. So you're correct. It's going to, and then also, you know, the employee can say, I need to get my money now when I leave. You can't arrange a payment plan and say, well, we'll pay you off, you know, over the next 6 months because we don't have the cash flow. So it does make financial sense. And if I can quickly run on already onto the temporary layoff and short time,
yes.
I mean, that is a much more cost-effective way to get through this time. So we'll get onto the temporary layoffs now, if that's okay. Or I see you
really go for it. No, that's fine. I think to summarize, you know, about retrenchment is it is neither a cost-effective nor a quick way to address sort of immediate cash pressures or to manage your payroll. Yeah.
So let me actually just go one step back. You know, I've already just touched on a Section 189A process. So like I said, if it's a large-scale retrenchment, and some of you that might only have just over 50 staff and maybe need to retrench only 10, you might say, shucks, how can that be deemed to be large scale? But that's what the formula in Section 189A says, you know, and the bigger the company and the larger number of people that you contemplate making redundant, all falls under 189A. And if it was a normal Section 189, in other words, you've got less than 50 staff, or you're going to make less than 10 people redundant, then Section 189 doesn't stipulate how long the consultation process should be. But we all know that to be procedurally fair, you can't rush it. So it's also going to take nothing less than 2 weeks up to a month. You know, employees start suddenly getting legal advice and then they delay and the process becomes quite long. So you're in for a longer ride, and it is far more onerous to do a Section 189 process than it is to basically consult with staff and say, right now we've got massive cash flow problems. Besides our 21-day lockdown, we need to make urgent or put in urgent measures. And one of them would be to see who can work from home. When businesses need people to work from home, we'll touch on that later when we get to leave. But for now, a temporary layoff, you know, seems to be a very easy answer to say to staff who you cannot allow to work from home or whose jobs don't make provision for them being able to function from home. You could put them on a temporary layoff, and our South African legislation doesn't regulate what the period is. So right now, you know, if you need to put somebody on a temporary layoff for 3 months, they'll still be able to claim unemployment, and they'll still be able to claim from the disaster fund. So there is definitely a way out here, and it makes absolute financial sense to say, if we know that this is going to turn, we're going to need these people in the long run, let's rather contemplate putting people on a temporary layoff. We don't need to consult until the cows come home. We do need to consult, but not as onerous measures as Section 189 stipulates. And where we can try and accommodate people on short time, the difference with short time and layoff is short time basically says what it is. It might be a case of saying, well, I've got work for some employees for 1 or 2 days a week, or maybe 1 week of the month. The rest of the time they'd be on unpaid layoff, or weeks on end or months on end on the layoff. The idea with a layoff is to try and circumvent retrenchments. And in our Section 189 process, companies are encouraged to look at short time and temporary layoffs as an alternative means to retrenchment. So it's deemed to be fair and reasonable.
So if I stop you there, I mean, we already know from conversations that we've had with business leaders in the travel industry that something that is happening quite extensively overseas, and I want to just test whether this is possible in terms of our labor laws, is that, you know, employees are in a kind of a mood where we are all, you know, feeling sort of solidarity, and what companies are suggesting to employees is to avoid any of your co-workers getting retrenched. Let's all work a 3-day week with the requisite sort of, you know, reduction in salary. And it seems, certainly from just sort of stories that we have heard, that employees are willing to do that in order to save everybody's jobs. So that kind of that would then count as a reduction. You know, that's not a layoff, correct?
Yeah, so in other words, if companies introduce shift systems, we've got companies doing that, where they've never had shifts before, just to try and have less sort of contact in the office, or exactly what you said. So, well, this team work 3 days a week, the other team work 3 days a week, and we sanitize the office after the first team have left, for example, where that's practically possible. Yes, great. And that means then obviously people only get paid for the days work. So short time does come with a corresponding reduction in people's salaries, for sure.
So can they make up that shortfall through any of the measures that the president has suggested, or through UIF, or is that only available to people who have been made, who have been laid off, or is that those benefits also available to people who have been placed on short time?
So yes, people that are placed on short time will be able to make up the shortfall in terms of the salaries that they're now losing out on, the portion, but the exact amount we are still unclear about. We do have a contact at the Department of Labour who's been trying to help us with clarity. So I'm only telling you now what we were told yesterday by a superior. This is nowhere to be found in writing. What we were told yesterday is that employees that are on short time can apply for UIF, and they should be able to get the difference of what their normal salaries was, before the short time, and what they're earning. But as we all know, there's a threshold. So the current limitation on UIF is 14,872. The current formula that UIF apply is between 38 and 60% of the 14,782. So when somebody is on maternity leave or gets retrenched or gets dismissed, they can apply for unemployment, and the formula is always on somewhere between 38 and 60%. And I wish I could purchase the formula they use, but the bottom line is we all know that the higher you earn, the sort of more chances are likely that you'll get 38% of the 14,872, and the less that you earn, the chances are higher that 60%. But what they haven't confirmed for us is how it's going to work with the short time. So because it's fairly new. So what we're assuming, and I'm just saying assuming because until we get this in writing, I assume that if someone earns 50% of their salary, and let's say that person already earns over 14,782, I can't see how that person is going to be able to claim, because they're already earning,
over the cap.
Yet to advertise that yet. I would not suggest that employers go and advertise to your staff and say, oh, don't worry, when you're on short time, you'll be able to make up the difference. We don't know that. We know that the lower earners will be able to, but I'm concerned about the people who earn over 14,782. I don't foresee that they're going to be able to make up the difference.
I suspect that certainly many of the women listening to the webinar will have painful memories of maternity leave. Because it does actually, as you say, UIF, was primarily devised to assist lower income brackets. And, because there's the supposition that if you earn more money, that you are saving, that you have a little nest egg, which of course is a massive assumption to make for most people. So I think it will be interesting to see how much of the UIF reserve government is willing to make available in order to avoid retrenchment. Because I think that seems to be a very large part of their economic strategy, is to alleviate sufficient pressure on businesses' cash flow, in the short term, but that they can keep their employees.
Yes. We were also told, just to add something else, the same superior at the department told us as well, that it's not just the strict formula. So yes, they will apply, 38 to 60% of the 14,782. They will also look at the credits, because people all have a pot of credits. So depending on how many times the person's been on maternity leave or how many times they've been retrenched. So the amount of claims that are already linked to that employee, plus how long they've contributed. So somebody who's contributed to the UIF fund for 20 years, will have more credits than somebody who's only been contributing for the last 6 months. So those are all things that we don't have the formulas. And all we're saying is, don't go and publicly tell your staff, don't worry, you're sorted, UIF will pay you out. We don't know the numbers. We're just telling you what it is for the normal retrenchment. The normal maternity leave was always between 38 and 60%.
I think that is a very important point to just emphasize as well, is that this is very frustrating, I think, and particularly because all of us are extremely anxious. The impulse will be to try and make an immediate decision, go away from this webinar and now start doing the math and making a decision. And I think I would certainly from my side strongly urge businesses to take an extremely deep breath, to focus on the practical, arrangements that you have to make before the lockdown starts at midnight on Thursday, and rather delay these decisions. And we all know, we're nearing the end of the month and the payroll is going to run tomorrow, but certainly, now's not the time to make these final decisions, because so much of this is still up in the air.
Yes.
It's worth waiting for the department to catch up with the president's speech.
Yes.
You agree?
Yes, absolutely.
Yeah. And it feels unnatural because you want to go into a kind of a crisis mode, but I think that everybody must try their best to stay calm.
Yeah. And
by all means, communicate with your employees that these things are under consideration, but don't be tempted to make rash decisions, certainly before we know more.
Yeah, for sure. I think what you said just now is that the assumption is that if somebody earns, under 14,872, and hopefully they've got a lot of credits, and hopefully they've been contributing to the fund, and hoping they get 60%, of their 14,872. If somebody earns under 8,869 a month, which would be obviously your more unskilled people, they should be relatively okay. It's the people that earn over that we need to be concerned about, because as you rightly said, they don't make provision for the rainy days. So can't give them false hope that they'll be able to make up the shortfall. But yes, so far what we have clarified is short time, temporary layoffs, and obviously shutdowns. And I just want to also tell you something else that we asked yesterday is there might be confusion between, do we have to shut down the whole place, for everyone to qualify for that 3,500 Rand that they've now made available for shutdowns? So if a business actually closes its doors for a month or two, however long, they're saying at the moment, 3.5 will be available for maximum 3 months, or the shorter period, in other words, if you're only closed for 2 months. But we were asking the question, what if a company doesn't close its doors, but only puts pockets of people on let's say, a temporary layoff? So some of your businesses that are listening now might have people that are able to work from home and people that need to keep the business running, but the majority need to be able to not actually work from home, but be on a temporary layoff. So it's not a shutdown, but it's a temporary layoff. They will still be able to qualify for claiming UIF, even though it's not a shutdown, meaning there's a chain around the door, everyone's gone home. It's if there's even pockets of people that are on a temporary layoff, we were told yesterday, those people will be able to qualify. So I'm hoping that our source is going to be correct.
Okay, so let's just maybe recap real quick. These strategies that businesses can take is, firstly, to shut down the whole business or the majority of the business. Another strategy is to put people on short time. In other words, your whole workforce is still doing something remotely, but you are only letting them work a certain amount of hours per day or a certain amount of days per week. And then, there's also the possibility of doing temporary layoffs for at least a part of your workforce. So would you say that's an accurate summary?
Yeah, if I want to just also recap, if our advice to companies is as follows, is saying, like you said, relax, take a deep breath, and then start again and saying, all right, of our workforce, who are the core people that we need to keep in the business immaterial, because it will be the captain of the ship that will go down with the ship if the ship does go down, regrettably. But we have to keep certain core people still on a day-to-day basis. That select bunch of people could obviously be granted the concession to work from home in the next 21 days and longer if need be. But then you have the right as an employer to revoke the concession if there's abuse. There can be all kinds of rights in that. You could say, well, we only need you to work part of the time, or all the time, or not all the time, 3 days a week. So it's like a bit of a short time, a bit of a work from home. You could even grant people the option to take paid annual leave during this time. You can't force it, but you could certainly encourage it, because a lot of the top earning people would say, well, UIF is not going to help me much. Is there any way I can take some of my paid annual leave over this time? It will just help the budget. So employers need to be sensitive and accommodating and have a whole mixture of recipes. So the one recipe will be, let's see who we need in the business to keep us safe. Those people, let's look at who we grant concessions to work from home and what are the conditions. Then we have a bunch of people who could be on annual leave. We could have a bunch of people who could be taking a bit of annual leave, then perhaps be on short time, and then perhaps go into a temporary layoff process. There might be people that go straight into short time, that can't even work from home, or people that go straight into, let's say, the temporary layoff now for the 3 weeks because they anyway can't work from home, and there's no short time because they can't work from home. So you might be having a mixture of everything. You might start with temporary layoff now for 3 weeks.
Yeah.
You might be slowly introducing some people back into the business on a short-term basis. You may have some people saying, well, can I take my leave after the 3-week lockdown? One thing that I am disencouraging rather, is to force people to take unpaid leave. Because if you think of the logic now, if someone applies for unpaid leave, they can't go claim UIF. If you call it a temporary layoff, then they can claim UIF. So it's actually the same thing, but it's not the same thing. You know, you normally grant
so you could unintentionally deprive someone of their right to claim by calling it unpaid leave.
Yes, exactly that. Yeah, so I think we need to work with our employees and not call it. You know, obviously in the past when people didn't have annual leave or family responsibility leave and they needed to take leave, we granted unpaid leave willy-nilly, but they could never claim. So I think you're right. We need to try and safeguard our employees as much as possible and call it what it is, which is a temporary.
Talk about, you know, remote working for a moment, because up until yesterday evening, we were getting a lot of questions about what if a person falls in a critical, you know, category or a dangerous category, and they want to work from home, but it doesn't exactly suit me as an employer for them to work from home. And there were a lot of questions about whether employees can insist. And what you said just now, obviously, was you can grant a special dispensation, but you can also take it away. But obviously, while we are in the 21 days, you know, you can't, I mean, we're all essentially being forced to accept that our employees work remotely, because unless you are in an essential service, you're not allowed to go to work. That is correct, right?
Well, yes and no. I mean, if I can interject there, because remember, a lot of businesses have people that are not office-based. If you think of office cleaners and maintenance people, and they can't work from home. So there's no pressure on the employer to say, well, you've got to keep paying these people for the next 21 days because you cannot allow them to work from home. It's not that you're being a nasty employer. The nature of their jobs just doesn't make them work from home. So that's why it's a concession. You as the business owners and managers have the right to say, we have certain people that have the tools to be able to work from home, or companies are making VPNs available and laptops and all these good things available. But it's the employers has the discretion here. The employee can't, you know, absolutely insist in saying, but it's not my fault and you need to pay me and I'm happy to work from home. Saying, well, your job just doesn't make provision. So you're going to have to take case by case and decide as a business, who are the people that we can afford this opportunity and the concession to work from home. And every employer, you know, are putting in rules and regulations, like how many times they need to check in. The one good thing about this working from home is it's going to either turn our world of working around. You're going to realize actually we can trust our employees. They actually were more productive working from home than they were in the office, so maybe it's a good thing. And we are naturally going to have a lot of abusers and a lot of people that are not disciplined enough to work from home. And that's why I encourage you then to revoke that concession, because if people want to be treated like adults, then they must accept the consequences. If they're going to misbehave, then that concession to work from home can be revoked.
But so while we're in the 21-day lockdown, revoking that concession, essentially then what we're saying is don't then make it unpaid leave, rather do a temporary layoff so that they can claim UIF. And then also importantly that you're not in fact forced to pay those employees, the ones that are not able to work from home.
Yeah. I mean, I think, you know, I'm being selfish now, talking with the employer hat on, not from an employee perspective. Employers need to survive. Businesses need to survive. The employees are going to be standing on their heads, very unhappy if you don't grant them the option to work from home. But you as the employer, you know, have to protect your businesses. You have the fiduciary responsibility to safeguard the employment of as many people as you can over the next couple of months. So don't make, you know, sort of decisions with the heart, rather make decisions with the head, because we are going to have a lot of unhappy people saying UIF is not going to help me, you know, I earn way over the threshold. and you might make some compassionate decisions which could harm the business. So I think you've got to be incredibly pragmatic now and take a business view and a long view, and saying, let's keep people working that we can, but let's not feel obliged and overcompensate when it's actually going to bleed the business. We need to keep the funds to last as long as possible. So this 21 days was not brought about by the employer. It's a government decision, and everyone, like you say, has to work together in solidarity now to say, let's protect our employers first and foremostly.
Yeah.
Make sure that the funds that are available are going to be there for a long time and not make silly decisions.
So let me ask this. I mean, do you have any advice on how to start this conversation with your employees, some strategies on how to communicate, and then perhaps if we could talk a little bit about, you know, given all of the uncertainty, what we know about how to start this process. You know, what is the procedure that you follow?
Okay, now that's a brilliant question, because you know, we've got so many companies, but I've never yet ever seen somebody have it in the employment contract that says something like the employer has the right to institute short-time or temporary layoffs. So, you know, you can go look at all your own employment contracts, but I'd be very surprised if any employer in South Africa has a clause like that says we can at any time put you on short-time or on temporary layoffs, because it's foreign to South Africa. We don't do this. So we can't just unilaterally impose changes to conditions of employment, because then we're going to have mass action. We're going to have employees taking you to the CCMA saying, my employer CEO just arrived one morning and gave us all an email or some communication instructing us to go on to short-time or temporary layoff. There was no consultation. So yes, these are strange times. These are, you know, I'm pretty sure that the CCMA are not going to be too accommodating during these times, and because they'll understand that the employer wasn't exactly being nasty, but, you know, put into this disaster management mode as well. But bottom line, what I'm getting to is you still have to consult. So the definition of consultation, I love the definition. There doesn't have to be agreement, but you've at least got to consult. So there's a notice that we've made available, Elizabeth, and I know you'll be sharing it with you know, all the delegates listening today. But bottom line is you have to consult. So there's a notice that you need to send out to your staff to basically say this is an intention, you know, of us to wanting to consult with you about intention, you know, the proposed layoff or proposed working short time. And obviously in that discussion, you will also advise there are some people that will be allowed to work from home, and these are the conditions. There'll be some people that can't work from home in this 21 days. You're going to be on the temporary layoff. There are some people that are possibly going to be put on short time. There might be a combination. There might be some people on annual leave. There might be someone taking bits of annual leave, you know, the whole mixture. So the idea is just to consult. And of course, the next question is to say, well, what if they don't like it? Of course, they're not going to like it, but you just have to consult. And the idea is to ask employees in that consultation, do you have any better proposals? Any other suggestions? You know, some employees are already coming forward saying, please retain as many jobs as you can. How about we all take a 20% cut in salary? You know, that's better than us all having to sit at home. You know, it alleviates the pressure on the payroll. So some employers are already today doing that. They're consulting with the staff saying, we've already had it from the lines. People are coming forward and saying, how about we all as a company take a reduction in pay? Some of us go on annual leave. You know, it's still cash flow for the company, but the idea is talk to your people and talk, you know, I don't know how you get to from you've got today and midnight on Thursday to reach out to everybody. And like I said, you're not going to get agreement. I'll be very surprised if South Africa really is as sort of, you know, comes together in solidarity as the president requested last night. But we're going to have some employees that are not so mature, and they are going to get nasty, and that's fine, you know, deal with it. But bottom line is consult. And then there's another document that we're sharing with you, which is the actual notice telling them of what the plans are. So if you're going to put people on short time, there's a notice saying you, dearie, are on short time from this date to this date, and these are the Mondays to Fridays schedules when you're working. And if this doesn't work out, we have the right to put you on a temporary layoff. So the idea is just communicate. So the notice of intention is we want to talk to you, and B, this is the decision. We are putting you on short time. Don't feel, I don't feel it's right to put people on what I call compulsory annual leave. Don't compel them to take the annual leave. Some people might say, I had intention of preserving my annual leave. You can negotiate with them and saying, it's a good time to take some annual leave, but you can't force it. So if the person doesn't want to take annual leave, then it's either short time where you can accommodate, or it's temporary layoffs. And if some of you have to actually close business for up to 3 months or even longer, then you call it a shutdown and you do that. But there's different strategies, but as long as you communicate, consult, and then let them know. And you've got like 2 days to do this.
Well, I mean, it's a difficult situation to be in, because we're also waiting, for some information that you need in order to make the calculation. So, it is likely that there's going to be, for most companies, there's going to be a number of days, if not a week or so, where they are still making the decision, but now their workforce is sitting at home. And it's then, I guess, that we are starting to talk about, right, particularly for those employees who can't work from home. How does, if we can talk through how leave will work now, right? Because it's unlikely that we're going to get all of our houses in order by midnight on Thursday, because these are complex calculations. So let's say the hypothetical is that next week people are at home, you haven't yet made the decision about whether you're going to reduce time or whether there will be some temporary layoffs. So how does leave work now? What are the things to look out for? And let's repeat what we have said throughout the conversation. I think that these are complicated topics. I think it bears repeating.
Okay. I think, let me just go back one step. When I say you've got 2 days, I'm pretty sure most of you have already put in some business contingency plans. I know many companies have already been planning this for the last few weeks. It's suspecting that we were going to have a lockdown. So there have been companies already testing the working from home for the last 2 weeks already. So hopefully some of you would have already decided we don't even need 2 days. We know already today who are the core people that need to keep this business going in the next 21 days. We know where there is work, and where we don't know, Elizabeth, that's a good point. You don't have to know that today. If you're saying we actually don't know, we might be able to do this week by week. So then you do it week by week. Then you tell the staff, for this week, from next week Monday, or from this week Friday until next Friday, this is our plan of action. And we will keep you all up to date next week, Thursday, as to what we're going to do the week thereafter. So those companies who can't plan so far in advance, then that's fine. Then you can do that week by week. But for now, to answer your question, Elizabeth, how are you going to start this? So the communication would go as follows: to say, the executive have already decided we need some people that are core that need to work from home. So these people will be working from home, and they'll be communicating with you and giving you constant updates as to what's going on in the business. So we'll keep you abreast. The balance of you are in groups. Some of you have already indicated that you'd like to take annual leave, and we encourage it. Now, some of you as employers might say, we don't have the cash flow right now to pay everyone, because it's just as well, it's like still paying their salaries, as Elizabeth said earlier on. You're still paying their salary while they're on leave. So it's not a reprieve for you. So some of you might say, well, we've got the cash flow to actually encourage us to take annual leave, and it looks better on our balance sheet when our leave balances are low, and we're going to have to pay out the leave anyway if we land up retrenching staff. So let's have maybe a balance of both. You might, as an employer, say we don't have the budget right now to let everyone take paid leave for 20 days. Some people might not even have 20 days. Most employers only grant 15 work days a year. So you might say, okay, maybe a mixture of both. I'll allow some of our staff to apply for leave, but maximum 10 days, for example, just for cash flow purposes. The rest of the days, because remember the 21 days is obviously not work days, because you only probably have people employed for 5-day weeks. So it's working days. And then the balance of those days, when you're not allowing people to take annual leave, then, as we said earlier, you could allow them to take unpaid leave. But my advice would rather call it a temporary layoff, because if you call it unpaid leave, they can't claim UIF. Call it a layoff. So if you grant annual leave for 10 days and the balance is then temporary layoff, or you grant a mixture of a little bit of annual leave, little bit of short time, and the balance temporary layoff. Or for those who can't work at home, for those who don't have annual leave, And for those you don't need on short time, this full period of 21 days and possibly longer than that would then be a temporary layoff. And for those of you that have got to close completely, we said already it would be a shutdown. So to answer your question succinctly, it's allow annual leave if you can. I wouldn't enforce it though. I don't think it's right to force staff to take annual leave. Invite it. It's just a nice combination to try and help their cash flow as well.
I think, a lot of people are asking, well, when is it sick leave? Have the rules around,
let me cover that already then, if I can.
Yep,
so,
go for it.
So needless to say, if someone, as we know now, if someone has come into contact with somebody who might be infected, and in your industry, there obviously are people that travel consultants, etc., that might be already worried. If there are people that need to be placed in self-quarantine for 14 days, then there is now a form available. It's called an employee declaration. And there's an employer declaration. So both the employee and the employer need to complete this form. It's just a one-pager, which Elizabeth will make available as well to yourselves. And that's all that UIF needs besides the actual UIF claim form. And the employers are going to need to use code 10 on the UI19 form in order for employees to claim, believe it or not, illness benefits. And this is completely contradictory to what we were told a week ago. We were told a week ago that when people place themselves on self-quarantine, it's not sick leave, it's not annual leave, it's not special leave. The employer has every right to say to employees, well, you're not sick, you're in self-quarantine, so you can choose. Take it as annual leave or as unpaid leave. Just yesterday, we got confirmation from the same source at the UIF department. And like I said, I want to see this in writing, but we were told in a supervisory capacity, who we trust, we know this person. She said, no, it's changed now. If people have been in self-quarantine for under 14 days, the employer and employee complete the declaration forms, and they don't need a doctor's note, and they can claim illness benefits, which basically there are illness benefits available at the Department of Labor. So for those of you who don't know, it also is applicable when employees' normal sick leave is exhausted. So let's just say somebody does contract the virus and they are sick, or even people get sick for other reasons. It's not just, as we know, coronavirus, but if other employees are sick in any time of the year, not just now during this period, when their sick leave entitlement is exhausted, they can also claim illness benefits if they are being booked off for 7 days or more after their 30 days of paid sick leave benefits have been exhausted. So let me just repeat.
Great. Yeah, I'll repeat that.
Somebody was sick, over the last 3 years, because remember the sick leave entitlement is if somebody works a 6-day week, and they ordinarily work a 6-day week, and if you look over a 6-week period, they generally work a Monday to a Saturday. In hospitality and in travel, that's probably the case. Then those employees will be on 36 days sick leave for a 3-year period. Employees who generally or ordinarily work a 5-day week, and over any 6-week period, you look at the roster and you say that they're a 5-day week worker, they're not a 6-day week employee, they then get 30 days of paid sick leave entitlement over a 3-year period. And that 3-year period is basically in line with their start date. So if someone started the 1st of January 2020, then for 3 years, that's their sick leave cycle. It's not financial cycles of the company or company's financial year end or SARS, it's linked to the employee start date. So if someone gets sick in their 3-year period and they've used up their 30 days of sick leave for 1 day here and 2 days there, you know how it goes. If they are sick and their paid sick leave benefits have been exhausted and they're booked off for longer than 7 days, then those 7 days after their 30 days have already now been exhausted, they can also claim illness benefits from the Department of Labor. That's always been there. In the past, it was 14 days, so someone would have to be sick for 14 days on the trot after their 30-day sick leave had been exhausted before they could claim. The UIF Act has been amended, and it's now 7 days. So basically, that same illness benefit fund, which has always been available for people that are really sickly, that have not used up these, that same illness benefit fund has now been made available for people that are in self-quarantine to apply. And that's why I said employers are going to have to use the UI-19 form and use code 10, which is basically for illness benefits. Then the other point is, if someone is infected with coronavirus and they have to stay, in quarantine for obviously longer than 15 days now, those people can still continue to claim, but they're then going to need a doctor's note or a medical certificate to validate why they need more than 14 days. So under 14 days, the employer and the employee declaration will suffice for them to claim UIF and illness benefits during self-quarantine. After 14 days, let's say they're not even sick, but the doctor reckons they still need to be in self-quarantine because they've maybe still exposed to others, or the immune system is still weak, and there has to be motivation by a medical practitioner for them to continue claiming. So there's a form called a continuation of medical benefits that the employer would need to fill out, and that means that poor employee will still be able to continue claiming from the illness benefit fund. Okay, and then obviously this is different. This is not different to COIDA. So some of the listeners will know that COIDA is the Compensation for Occupational Injuries and Diseases Act, and it's basically the same, what we call workman's compensation. So if somebody does contract COVID-19 because of the work and because they've come into contact with travelers or people that are infected, then it will be a different process. Then the employer is then obliged to still complete all the forms for COIDA. And then how that works is the first 3 days when somebody is booked off work because of a work-related injury or disease, in this case, if someone is infected, the first 3 days, the employer has to pay in full, and I'm going to explain that a bit further now. And then from day 4, the employer then could still pay the employee, but then at 75% of their rate of pay. And then if they are still booked off for longer than 3 months, then after month 3, they can then continue claiming, but then it goes to UIF. So on the forms that the employer completes when somebody registers a workplace-related injury or disease, the employer needs to indicate on that form whether they are prepared to make payment for the first 3 months. Some employers, cannot. They'll say, we don't have the cash to pay this person for 3 months at 75% of their rate, and then they could go and claim it from UIF. And this is actually contradictory now to what UIF are telling us, that people can still be in self-quarantine, but UIF department and COIDA do not talk to each other. So you have to phone 2 different departments and check what's best for the employee. But I just want to also explain that first 3 days that I've told you about now, this is nowhere, to be found. It's not, or put it this way, it's not common to employers, but the first 3 days when someone contracts a workplace disease or hurts themselves at work, those first 3 days that you are required to pay doesn't come out of their sick leave. So an employee, we don't advertise this to employees, but the employees have the right to say, you can't touch my sick leave. My sick leave is my sick leave. Those are 30 days for when I get sick. If I get hurt at work or I get COVID at work, those first 3 days that you as the employer pay, it's called WCA leave or COIDA leave. It doesn't come out of my 30 days. So just that you know that, because that's not publicly known, but it is a fact that you can't touch the person's sick leave. So the first 3 days you pay in full, and from day forward, 75%.
I didn't know that. I don't mind admitting.
A lot of people didn't know that. I only found that out 2 years ago as well. So it's not common. Yeah.
That's sneaky.
Yeah, well, that's again something that to the employees, because otherwise they might be encouraged to hurt themselves at work. I'm serious. People, hurt themselves at home and then claim it was a workplace injury. If they know it's not coming out of their sick leave and the employer has to pay, that's why we don't advertise that information.
Okay.
So I've got a point, but that's
no. I think it's all important.
Yes.
So we have quite a few questions. I think. Let's start working through them, because I'm sure that will also prompt some more conversations. So the first question is, I'm just going to read it. I employed someone 2 months ago. They are still in the probation period of their employment. It has not been able to effectively work purely because of lack of business, right? So because of the shutdowns, I'm sure, the travel bans. Can I give her a week's notice? I cannot imagine this resolving soon.
Okay. Well, firstly, the fact that the person's on probation, would not be a reason to dismiss them without a procedure. So the probation period is there to check that the person can do their work, that they assimilate into the work environment, that they adhere to company policies and procedures. So it's mainly used to check performance. Now, because the person hasn't been there, it's understandable that the business can't see if they're going to be successful. But it sounds to me that this question is more about that you don't have work for this person.
Yes, it's more a redundancy question.
So that's actually, you'd still have to put this person through a Section 189 process. So let me just give you another example. We've even got cases now where companies have employed people to start now 1st of April. And I'm already getting calls saying, we've just had clients cancel contracts, and in your case there are a lot of companies that are obviously knowing that travel plans have all been cancelled. Now what? We employed this person in good faith 2 months ago, they've served their notice and they're about to start, but we need to make them redundant because we don't actually have work for them. So I'm busy making people redundant who haven't started yet. So the lady or the person who asked the question, it's the same process. The person is still in their probation. You unfortunately are still going to have to subject them to a Section 189 process or a 189A, depending on the size of your company and the number of people to be possibly made redundant. It's the same process. The only difference is that most employers have a shorter notice period during probation than after probation. So those of you that need to make people redundant, look at your employee contracts, because as I said, most employers would say something like during probation period, either party may give each other 1 week's notice period. After probation period, the standard notice period provisions would apply. So if you just apply the basic conditions of Employment Act notice periods, then if someone's been in your employ for 6 months and less, you would only need to give them 1 week's notice. If they've been in your employ for 6 months up to 12 months, you're then obliged to give them 2 weeks notice. And then if they've been with you for more than 12 months, you're obliged to give them 4 weeks notice. However, your employment contract supersedes what I've said now. So if you've got people in executive positions that you've already contractually bound them to longer notice periods, like 2 calendar months or 3 calendar months, or a calendar month on the 1st of the month, or a calendar month on the 15th of the month, then you can't now go and apply the basic conditions of employment formulas, because that's unfair. You have to then contractually apply what you've agreed to in the contracts. So for the person now who's got the probationer, if the probation period says you're on 3 months probation, and in this period you are only required to serve 1 week's notice, and even if you don't have that in that employment contract with that person, you can still fall back on the basic conditions of Employment Act. So if we had to quickly do a time plan with this person, you would have to call this person in, give them a Section 189 notice, and we can make templates available, Elizabeth. I'm happy to do that. A Section 189 notice is basically, it's a letter that gets given to anybody that you're contemplating making redundant. It starts off with the rationale, in other words, the business case, why we need to make people redundant or contemplate making redundant. And then we go into the alternatives, and alternatives could be things like, we could put you on a temporary layoff, but it will be like kicking the can down the road. We can't see this turning around, or we could put you on short time, or we could put you on 4 months unpaid leave, or temporary layoff rather. Alternatives could be, we could put you on a half-day job or a half-day salary. I mean, alternatives, you have to look at alternatives. And then you put in the timelines where our Section 189 legislation doesn't stipulate or doesn't dictate to employers how long you need to consult. But the law is clear, you need to consult, they call it meaningfully, and you need to engage with employees. So you would be very, I would say it's risky to give someone a Section 189 letter today, and then tomorrow call them in and say, we're done consulting and here's your retrenchment notice. That would not look like. So the idea would be to consult for at least a week or two. My advice is always at least 2 weeks if you can, look at all alternatives. Meet with that person at least twice in this time, explore alternatives, and if you can't save their jobs, then you give them a notice, a termination agreement. If the employee doesn't sign the termination agreement, then it doesn't mean that the employer cannot retrench. The employer then gives the person a notice of retrenchment. So it's different. But the bottom line is there's a process that you're going to have to follow, even if it's a probationer that you need to make.
So obviously for some people who are listening, unfortunately, I'm sure that there are people who are thinking, well, I don't have that much time. I don't have that much cash left. So, to take a 2-week period of consultation. If your business case, as you say, your reason for retrenchment is sufficiently sort of severe, the shortfall that you find, or the predicament that you find yourself in, I'm sure that then shorter periods would be justified.
Well, Elizabeth, I agree, but at the same time, the president specifically said last night, we shouldn't get into panic mode and start retrenching. So if you think about this, the 3 weeks of the shutdown now, lockdown, is actually plays into the employer's hands. So if you know that your business is not going to survive beyond the 21 days, if you know that it's like I said, kicking the can down the road, if you know that even in 5 months' time, nothing's going to change, you're still going to need to make people redundant. There's nothing precluding you from starting the Section 189 process now simultaneously with the lockdown. So you could say to people, I'm giving you Section 189 letters. I'm terribly sorry. It's got nothing to do with the lockdown. The lockdown just happened to happen at the same time that I was planning on having the conversation with you anyway, because we've known the travel industry is in its, obviously
dire straits. Yeah.
You know that. So you could say, the same was happening today. We've got people that we're having to have the discussions with today who knew that this speech was going to happen last night. So they're going to think it's to do with last night. It's not
connected. Yeah.
Yes. So yes, I'd run the two processes simultaneously. I would talk to people that you know that you're going to need to make redundant, start the process now, and you could put them on a 3-week, temporary layoff. So they actually going to benefit. If you retrench them now in a week, they're actually losing out on the next lot of days, because they could actually be on a temporary layoff. So put them on a temporary layoff for 3 weeks. It's not going to cost you money. Then you've got 3 weeks in which to look at alternatives.
Consult. Yeah.
3 weeks in which to consult. There's nothing prohibiting the two of you from talking to each other, remotely in the next 3 weeks. Employees come up with the most bizarre ideas. Sometimes they come up with wonderful suggestions, like, can't I consult to you? You only pay me for when I work for you. Then I'm free to consult to other people, and you pay me for my time. I become an independent contractor to you. There's those kind of discussions. Or let's fine, I'm not going to fight it. I'm happy to go. Where do you want me to sign? All these kind of discussions will happen, but don't rush it. And I would say use this 3-week time now to consult meaningfully. Then at least from a procedural point of view, you're not going to get accused of rushing it. From a substantive point of view, because I'm jumping ahead now, an employee runs to the CCMA after you've made them redundant, and if they claim it was an unfair retrenchment, the commissioner would ask, why are you claiming it to be an unfair retrenchment? Is it from a procedural point of view or substantive? And most employees would say both. Then the commissioner has to unpack and say, why do you say procedurally unfair? Did your company not consult? Did your company not consult with you meaningfully? No, they rushed it. They gave me a letter today, and the next day I was retrenched. Then you're going to burn, and I can tell you now, employees will probably be in for at least 3 months salary for that employee because you didn't follow procedure. So do you understand why I'm saying don't rush it? Even though Elizabeth's point is valid, that there's business case now to say we don't have time. You do have time. Government have just given you a 3-week lockdown where you're not compelled to pay people. Put them on the lockdown. Use the time to engage and consult. And then at least you've ticked the box. From a procedure point of view, you've got time to meaningfully engage.
So there's a related question here. Sorry to interrupt you, but so someone just asked how much notice is required to be given to employees for the temporary layoff option?
Okay, that's a good question. Some bargaining councils actually make provision for the minimum period. Now, none of you would probably fall under any bargaining councils, but there's nothing in the basic condition of Employment Act that stipulates a minimum time. And there's, as I said, in some bargaining councils, there's something like 5 days notice. In this case, you don't have time. We don't have 5 days time to give people. So it would be, in these exceptional circumstances, be quite understandable to put out notices today to say to people, as from midnight, you're on a temporary layoff for the next 21 days, because that's out of your hands. Government have imposed this, so you're not going to be deemed to be unfair because you haven't consulted. So all you need to do is, like I said, put out a notice. and invite people to consult, because people will at least want to say, but I can work from home. You know, what if I write up a training manual from home? You know, we don't have one in our business. Can't I do that instead of being on unpaid, temporary layoffs? Let people at least come back to you with some suggestions. Let's say if I close a business tomorrow, that would be a fair time to say, I'm giving them notice. I'm giving them an opportunity to make suggestions.
There's another great related question. So can we apply a combination of short time for key people and temporary layoffs for others? Will this be seen to be fair and non-discriminatory if the selection can be justified?
Absolutely. Yes. I said that earlier on. So you could have, we said you could have, in any business, you can have a number of people on full pay because they're keeping the ship running, and you can justify why we are keeping these people totally on full pay and why they're working. We have to justify why we have some people on paid leave, why we've turned away other people's leave requests, why we've limited the leave to X amount of days per person because we have to watch our cash flow. We have a bunch of people on short time and we have a bunch of people on temporary layoff. As long as your business rationale for each group is justified, because you may get challenged. We might get the outliers who are going to deem there to be favoritism or unfairness. So be ready for it. And that is a perfect question.
Okay. And then also still on the topic of, I'm just trying to go through all of the temporary layoff questions while we're on the topic. So this person typed, to confirm, temporary layoff is no work, no pay, and can be for an extended period of time, but the job is protected.
Yes, that's the idea. Exactly. Yes.
So the job is preserved.
Yes. So remember, for all of you, there's no reason why you can't say, well, the disaster fund is available for 3 months. So perhaps let's just use it. Let people use that it's only 3,500 Rand. It's the minimum wage. It's nothing, for people that are high earners. But you might say, well, let's write this out. Let's put our staff on a temporary layoff for 3 months. Let them get that 3,500, especially in jobs where we know they're not easily going to get work this time of the year. And then if we have to retrench them, let's start talking to them. Let's say in month 2, because we have to factor in notice periods, we have to factor in consultation time. So I would say run the two concurrently.
Parallel, Because there's another question. Can we apply temporary layoff to staff who can work from home but will not be required to as there's not enough work? It's exactly the same argument again. Rather put them on the temporary layoff, but at the same time start the retrenchment procedures so that you can take this time to do the necessary consultation, etc. In case once the lockdown ends, you still want to retrench, then at least you've started the process. That's correct?
Yeah. So again, that's again the decision about the head and the heart. The heart might say, Shane, you are putting good proposals to work from home. But if it's non-core business, I'm using a silly example now that I used just now about the training manual. If I say, but don't put me on unpaid leave or during this temporary layoff, I can write you a training manual, and you might say, my dear, we might not have a business to run in 3 months' time. I don't need the training manual. It's not a business imperative project right now. That's on hold until further notice. So then while your compassion might be, I would like to help the person, it's not a business core, need right now. So it makes sense to rather preserve our funds for the rainy days and then say, sorry, dear, can't accommodate your request. You're going to go into the same pool as everyone else that's going to be on a temporary layoff.
Okay.
So, yeah.
That's perfect. We've got quite a few questions about the formalities involved in both of these cases where you have to consult and give notice, etc. And people are asking the question whether all of this needs to be in writing. There are some questions about using other types of electronic communication, so WhatsApp or SMS. Do you have some thoughts around the format and channels that people should use, given that we're all now being forced into remote working and it might not have been the way you did business before?
No, that's a great question. A lot of employers, you're right in saying, I've already invoked, the work from home for the last 2 weeks already. So you are a lot of people working remotely. So yes, any communication that works for your business will go, as long as you can not be accused of just unilaterally imposing, amendments to contracts because you're now changing it. Now, I know we'll have government behind us saying, well, we didn't exactly bring this about. It wasn't like the employer's decision. We don't have a choice, but it still means that you need to consult. So to be safe, I would still say put out some, whether it be a WhatsApp, a SMS, an email, just saying as a result of the president's speech or announcement last night, we don't have a choice, but from midnight, everyone is going to be at home on a temporary layoff. Nobody is required to work, or those that have been or asked to work, have been contacted directly. If you don't hear from us, stay home until this date. That's fine. But at least say, any proposals during this time or any suggestions are welcome. That's all I'm asking you, is to at least put it out there saying, you're expecting us to consult when it's actually not, it's a decision made that's out of our hands. Yes, I know that, but at least give people an opportunity to speak and come up with suggestions.
Sure.
Yeah,
and I mean the channel in which you do that, whether you use email or SMS or old-fashioned letter, etc. And what you need to think about is how you preserve the evidence of the process, right? So particularly if I had to just speak for a moment, because I'm quite passionate about the whole WhatsApp, using WhatsApp for work is dangerous because it's not a work account. In other words, the employee leaves, for instance, are you sure that you have a record of all of the messages, etc.? So just unfortunately, in these circumstances, am I right in saying you need to think about how do I prove that I have taken all the steps if the employee wants to take me to the CCMA?
Yeah. Okay. So let me just go back one step as well. For the 21 days, you are protected. As an employer, I wouldn't care too much about having tons of evidence, because like I said, this decision for the 21 days from midnight to Thursday is out of our hands. However, the president did say last night, that where employers can, they must continue still working. So an employee can say, but employer, you just want to close the doors. Did you not hear that the president said we should try and keep our economy going? So why can't we work from home? So that's the concern, is that you're going to have some clever, challenging people saying, but why can't we still work from home? Why are you just shutting down because it suits you now to put us on the temporary layoff? So for that reason, it's safer to consult. But what I'm more worried about is the period after the 21 days.
Yeah.
So after the 16th of April, a lot of you are probably going to say, this is just a tiny period. After the 16th of April, we are still going to be required, as our businesses are not yet making it, to put people on short time or probably extended temporary layoff. That's the time I'm more worried about, because that is then not a government decision. You would then, before the 16th of April, if you know that you're going to need to keep people on a temporary layoff for, let's say, 3 months or longer, that's the time when you really do need to have some paperwork and saying, we didn't just wait until the night of the 15th of April to notify all our staff that we're extending it. We actually invited them to consult on the 10th of April, saying, it doesn't look good. The 16th of April is going to come and go. We're still not going to be ready for you to come back. Our forecast of sales looks still dim. We foresee this is going to last until the end of May. Anybody that has any proposals or suggestions are welcome to forward it to person X. That's the invitation to consult. So yes, I'm answering your question. The first 21 days, not too stressed about that, because it's out of your hands, except where you're going to have staff challenging you, saying, why can't I work from home? But after the 21 days, that's when you do need to have business cases and rationale and just notices that you did invite people to consult. Does that answer?
It answers it perfectly. Maybe just to emphasize again, because there are a couple of questions that has the scenario where a person by the nature of the job can work from home, except that we all know that there aren't really bookings coming in right now. Those two things you also need to, as I see it, separate in your mind, because again, that is more a conversation around redundancy, and then again, the person might be a candidate, should be a candidate now in the short term for a temporary layoff, but at the same time start the retrenchment procedure if you think it's unlikely that your business volumes will pick up after the 16th. So I think we've chatted quite a bit about that aspect. I see that there are quite a few questions about the UIF.
Okay.
So maybe we can go through that again. And I must just again remind everybody that if it seems a bit confusing to you, you are not alone. Unfortunately, I think everybody's a bit confused.
Yeah, sorry, Elizabeth, I just want to go back to your previous person's question. What you could also do with that person that says, I can work from home, but the business argument would be, well, that's great that you can work from home, but there aren't bookings coming in. You could actually then rather, like you say, either have core staff saying we're only keeping one person available and all bookings that come in go to that one, or we pay you by the hour. So if you are in a period of temporary layoff and we get 1 or 2 inquiries, you'll get paid for that time, no problem.
Okay.
So you can actually try and still keep your business going and still handle business inquiries without putting everybody on a temporary layoff. But I mean, staff should be very willing to spend a few hours a day and not necessarily expect to get paid for the day. You can say, well, I'll pay you by the hour when there is work. We have to preserve our time. Yes.
And so that's almost like a form of short time, correct?
Yes.
Okay.
But that's going to be like, if it's just a couple of hours, it might not even freaking qualify as short time.
But no, it's almost no time.
Let's keep the business going. Let's still handle inquiries. Let's make this thing work, because this is, like we all know, it's unknown waters for all of us. All right.
Yeah. Okay, so I'm going to read one of the UIF questions to you now, if you're okay with that. Yeah. So this person feels exactly the way I'm feeling. I'm a little confused regarding the UIF options. Claiming UIF for short-term payment and layoffs with the percentages you mentioned, as with maternity leave, seems to overlap somewhat with the shutdown option, which is the 3,500 rands. Can you claim both, and what would be the difference?
Okay. Yeah, that's the same queries we had yesterday, all right, or the same questions we asked the department yesterday, all right. So let me try and sort of summarize. When someone is put on a temporary layoff, they can go claim UIF. What we've been told is that it would be the difference, sorry, not the difference, it would be between 38 and 60% of the 14,782. That would be, for example, where you have pockets of people on a temporary layoff. You might say that the examples we use, we've got some people working, some people on part-time or short-time, some pockets of people in our business on a temporary layoff. We haven't shut the doors down. We're not closing our offices for 3 months. So those people that are on a temporary layoff can claim between 38 to 60% of the 14,782. That's what our resources told us yesterday. The 3.5 is when companies actually close the doors. Because if you look at 3.5, it's the minimum wage. It's basically saying we're closing our doors for maximum 3 months. There's nothing going on. And that's the disaster fund that's been made available. So that's different to a temporary layoff where you have pockets of people. I know it sounds like it's overlapping, and that's exactly the same frustration I had yesterday, trying to understand what's the difference. So we were told the difference would be, like I said, we have pockets of people on a temporary layoff, and it'll be a week here, 2 weeks there, maybe a month. It's not the same as just closing a complete shutdown. And
but
then
so would people be entitled to both? Sorry, if there is a shutdown. It's
no,
one or the other.
No, definitely not. It's still coming out of UIF, so I can't, I'd be very surprised. Well, maybe
you can't double dip.
Yeah, I doubt you can double dip. If that system is not, you never know.
Okay.
We'll soon find out if people are doing that. And then the same with the short term. Yeah.
No, so the other question, sorry, that this person has added is, so how does that work with this TERS or TERS, as we've started already calling it?
That TERS is brand new. We heard about it yesterday for the first time. It's not existed in the past. We have no idea yet how that's going to work. I don't even know yet if that's going to be governed or managed by UIF department. Is it going to be another wing of the UIF department? We know as little as you know. So that's the kind of implementation we're going to hear about after 11 today, as to how that's going to work. And then hopefully there could be either another webinar that we can share that information, or make it just available on slides or something.
On an FAQ. Yeah, no, we'll definitely make it available.
No, I assume, and I'm just saying assume with capital letters, I assume it's going to be linked to UIF. It's going to be another form of a UIF that's now being made available.
And it could be in addition to the existing dispensation. Yeah.
I think, again, that we know now UIF is predominantly there, as Elizabeth, as you said earlier on, for the lower income workers. But I mean, there are so many of our population that are way above that threshold.
Yes.
It's going to sink a lot of people. So I'm hoping that that's going to make available for funds for people who earn over the UIF threshold.
To make good that shortfall.
Yes.
There's a process question here about the UIF application. So must the employer do the UIF application for temporary layoff or short time, or is it the responsibility of the staff member?
No, it's definitely not the employee's responsibility. What is quite amazing is that the department have actually indicated that companies can actually reach out, to your local department and ask them to send out officials to come and help with the paperwork. So especially in large companies where there's going to be volumes of people, they are making people available. But I really, with all due respect, can't see this working. I mean, I can just imagine how small or how limited their resources are going to be. So advice would be rather employ your HR people and whoever runs your offices to assist. The available forms will all be on the Department of Labor's website. So, and as we get, we've already got some forms that we can also share as well that are available, and they're straightforward. I mean, most employers know what a UR19 looks like already because you've been using those. They've just added a few more reason codes. So they've added a reason code number 17, which is when people are on short time. So it's called something like reduced hours or something. So you'll tick that box when people are on short time, because remember I said earlier on, our understanding is that when someone's on short time, they can apply for UIF for the balance of
so it's a proportional claim.
Yes, so there's a form already available for that. UR19 been embellished a bit more, and it's a case of just send them in. I don't believe you should wait for someone from the department to come and pay you a visit if you're going to wait for a long time.
Maybe another question about capacity. Someone asked, with the CCMA currently also closed, do we maybe know if they are working online or remotely and whether they will be processing any applications?
The CCMA or UIF?
Yes. CCMA,
CCMA are still working. So employees can still fill in, LRA Form 711s, and they can still refer disputes electronically. The CCMA commissioners are still doing pre-conciliations and even conciliations telephonically. So the commissioners are still working at the moment. They're just not having face-to-face arbitrations. We even have a Skype arbitration that's been postponed, strange enough. But basically, all pre-conciliations, all paperwork administration, that's still going on, yes. And I just wanted to go back to what you've asked.
Go for it.
I just want to go back. I'm surprised that the question hasn't come up about when I said earlier on that, whilst government has now imposed this lockdown, I know that some of you as employers might be saying, how on earth can our employees even think about taking us on to the CCMA for an unfair labor practice? Because I told you earlier on that you can't just naturally impose amendments to conditions of employment. So unless your contract says we have a right to put people on short time or temporary, which I said earlier on, I doubt your contracts say that. So we can't just go and change people's hours of work or days of work or pay without consultation. So what would happen is, if you're going to get aggrieved employees in this time, they could just download a LRA Form 711 from the CCMA website, fill it in, send it on to the CCMA electronically, serve it on you to prove that they've got what they call service delivery. And you might get the phone calls from the CCMA commissioners phoning you to do a pre-conciliation. And we've had a whole lot of employees filling in LRA Form 711s. Sometimes it'll be 1 plus 30 other. In other words, one person refers it, but has 30 other employees' names all attached to that same referral. So you might have a case of like 31 people, believe it or not, it happens. And you might, as the employer, be so discouraged, saying, I'm forced to impose this lockdown, and now I'm being taken to the CCMA for an unfair labor practice because I've amended people's conditions of employment in terms of hours of work, days of pay. And that's why we keep saying, whilst this feels so wrong, that you need to give people notice and that you need to consult. You must be all fuming at me for saying it. Do you understand why? I'm just saying tick the box and show in good faith you're open to suggestions, even though the 21 days lockdown is imposed by measures out of your control. It's after the 21 days that I keep saying is the important part.
Yeah. Okay, so in keeping with sort of the procedural questions, I'm going to read this question to you. When we put staff on temporary layoff, can you explain how the pay works? We obviously put their salary on hold from this side. Do they then physically go and queue with what paperwork? And if they are earning 20,000 Rand a month, does that mean that they only earn a certain percentage? How do we guide them to get their salary? It's almost the same question as the previous one. about just physically how the UIF payments work.
Yeah, okay. So basically, the employer would have to fill in a UR19 form, and it would basically be the employer's responsibility to give the form to the employee. There is no online process at the moment. So yes, they're going to physically have to go to their closest department of UIF to go and actually submit their claim. They have to fill in forms there as well. So yes, there's no electronic. There are only electronic processes with maternity, as some of the ladies that have been on maternity leave would know, but they don't for any other purposes. They're going to have to go and queue. Like I said earlier on, if you're a large company and you have large volumes that are going to be on temporary layoff, you can certainly try your luck and phone the departments, the local one, close offices, and ask them if they can send out an official to come and help with the paperwork. But the onus is definitely on the employer to fill in the forms, give it to the employee, help them as much as possible. And at the moment, there's the normal UR19, like I've already told you. Number 17 is the new code that they've added, which is called reduced work time. There's one called 14. It says business closed. So you could use any of those, because it's not a dismissal, it's not a retrenchment, it's not a maternity or adoption, it's not absconsion. You literally are limited to those tick boxes and the poor employer. And then to answer the question about the pay, it's our understanding that employees that earn over 14,782, unless government tell us otherwise, nothing has changed. The limit is still there. So if someone earns 20 and they're not going to be able to work at all, they're on a temporary layoff, they're going to be in the same queue as somebody who earns under 14,780. What did I say? 14? I'm getting my numbers wrong.
14 odd thousand.
Someone
asked whether that amount gross or net of tax.
That is gross. So in other words, if you look at your pay slips, those of you that earn over the UIF threshold will see that you're paying, was it 147 Rand 82 a month, something like that. So that means that's the current UIF limit. So the person who earns 20,000 a month would apply for unemployment, and unless they tell us differently, that person is going to get 38 to 60% of the 14,782.
Yes.
Like I said, our history proves this, that the higher the person earns, the more chances are that they're going to get 38 or 40%. And the lower the person earns, the chances are greater that they might get 60% of the 14,782. So the poor person who's on 20 or more a month, you literally have to say to them, I know UIF doesn't feel like it's worth it right now. It feels like petty cash. It might just pay your grocery bill, but it's something, until TERS kicks in, maybe that will be a better benefit.
But so just to be clear, because there are a couple of questions, if a person earns more than the cap, they can still apply for UIF. It's just that 38 to 60% is worked out on the cap, not on the higher salary. So someone asked whether you can still apply, and obviously all of us are entitled to claim under the UIF. It's just that they place a cap on that maximum amount.
Yes.
Then work it out as a percentage. I want to squeeze in two more questions if we can. One was, what about staff that are already on paid maternity leave? Can they be put on temporary layoff during this period of when they are on maternity leave?
Yeah, that's a very good question. We haven't seen that one coming yet. But if someone's on unpaid maternity right now, I'm assuming that person that we're talking about now is on an unpaid maternity.
This was actually on paid maternity. Yeah.
Okay. Yeah. Then the company would have the right to say, well, sorry for you, we have to now change the conditions. But, I just think that's going to be a compassionate decision that each employer is going to make, because remember, there's no legal right to pay somebody while they're on maternity.
Yeah, exactly.
You might have entered into a contract with that person, like a work back contract, saying we'll pay you your salary for 4 months, but then you need to come back and work for a year. So if you're going to renege, and change your contract, you're going to have to consult, because I think that's going to be a bit of poor faith. And if you've got lots of people on maternity leave, I can understand that that's going to break the bank. But on the other hand, my logic says they weren't working anyway. and you probably made provision for it anyway because they were on paid maternity. So the fact that
Sure.
there's a lockdown now during their maternity, I still feel, from a compassion point of view, I'd say carry that cost. If they were expected to work while they were on maternity leave in exchange for getting X amount of money, then you might argue differently. But I think that's going to be a bit of a tricky one.
And then maybe a question to wrap up. Let's for the moment imagine that on the 16th of April the lockdown gets lifted. These options of temporary layoffs, short time. Am I correct in saying that those options remain available after the 21-day period?
Yes, for sure. And we've already, and I can imagine in the travel industry, you probably all know that even if it is lifted on the 16th, you probably all know that your requirements to still have staff on short time or even on layoff is going to go beyond that. And that's fun. And that's why I encourage you to use this 3-week period now to start consulting with staff to say, we've got options. We don't see things changing after the 16th. You can still take leave. You can still be on unpaid. You might have some people trying to encourage you to say, well, rather let me go, rather retrench me. And you might say, but I don't want to retrench you because this COVID will be over at some point and we need you back again. So even if it means 6 months, as I said right in the very beginning of our webinar, is don't be compelled or forced to retrench people that you're going to have to
need again. Yeah.
I know it feels very unfair towards the employees because they say, I'm losing out on my retrenchment package. You're now forcing me to resign. Saying, I'm not forcing you. I'm trying to keep you. I'm trying to retain you. Keep claiming as much as you can. From UIF, we'll support you in this process, and hopefully your industry will get a cash injection just to help you, through this process.
Well, Fatima, I have to say thank you very, very much. It's been incredibly informative. I imagine that a lot of the people who are listening are suffering a little bit from information overload. The stuff is complicated. So just want to reassure everybody that even if we didn't get to your question, we will be publishing FAQs. We will be giving you more guidance, certainly as we hear what the ministers have to say about how all of these things are going to work. So keep asking your questions, keep sending your questions to us, and we will try our best to answer them for you. Thank you for your time, Fatima. I'm going to hand back to Nat to wrap this up.
An absolute pleasure.
Wow, Fatima, you are a font of knowledge. I just want to spend the entire day with you. Thank you so much for all your help. And just to reiterate Elizabeth's comments, we are collecting all the questions that we have received. Sorry, we were not able to get through all of them. We had over 70 questions come in. So we will prepare those FAQs for you soon. We are recording the webinar and we will release that recording today. So please keep a lookout on your ASATA mailers and also on the coronavirus.asata.co.za website, where we will upload the webinar. Thank you to you, Elizabeth, for prepping everything. And for the rest of you, we are standing in solidarity with you. If you have any questions, if we can help you, if there's anything pressing that arises, please reach out to us. We are here to help you. Thank you again and try and have a good day. Goodbye.